Good morning, folks. We're going to get started here in just a second. Chairman Robbins is having some technical difficulties, and so we're going to give him a couple of minutes to sort that out, and then we'll get started here.
Oh, Mr. Chair, you're on mute.
Okay, can you hear me? Okay, are we ready to roll? Sorry, I had to take a call.
We are ready. We can begin with a roll call if you'd like.
Let's do that. Thank you.
Commissioner Ackerman,
Present.
Commissioner Bowe, Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Thanks, everybody. Good to see everyone today and good to be here. We have a not too heavy agenda today. The first matter on our agenda is commissioner comments. Does any commissioner have comments? And if you do, just speak up. I'm having to attend via phone, so I cannot see everybody today, unfortunately. All right, seeing no commissioner comments, we did not have anyone sign up for either written or verbal public comment, so we will move from that. Next up is the consent agenda with 5 hearing officer recommendations. Does anyone have questions concerning consent? Seeing none, do we have a motion to approve consent?
I'll move to approve. Second.
Motion and a second to approve consent agenda. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Again, because I'm visually impaired, I cannot see if the director is with us today. The next item is potentially a director update, but if that's not necessary, but do want to give her an opportunity.
Thank you, Chair. I might defer that a couple of weeks, if that's all right.
That's perfectly fine. Good to see you. Thank you very much.
Yep.
All right. We will continue to our next agenda item. That is an oil and gas development plan, docket 2206-00164. This involves CCRP operating, and it is the SUMAC 1265-13 OGDP. And I believe we are set to hear from the applicant's attorneys today, along with a PowerPoint presentation and some other additional information.
Thank you, Chair. I'm just going to wait until all of our panelists are admitted before I begin, and we will bring up our PowerPoint. So thank you. Looks like we've got, I believe, everyone. So we'll bring our PowerPoint up and then I will get started. Okay. Well, good morning, commissioners. My name is Kelsey Waselinki. I'm with Jost Energy Law, and with Jamie Jost, we represent CCRP operating in the SUMAC 1265-13 OGDP in docket 2206-00164. And we appreciate the time to present to you today. We do have a team from Petrotech Engineering who submitted the geology and engineering testimony in support of this OGDP here with us. And we have a short PowerPoint that we'd like to briefly present to you today. Next slide. So after our presentation to you on February 1st, we believe that 2 issues remain in this matter that CCRP would like to address. The first is the requested 4-well density, and the second relates to CPW's preference for use of an existing location. On the first issue, I have here a few excerpts from the director recommendation that are relevant. It's important to note that the director acknowledges that production data is limited in this area and that the requested spacing meets the requirements of the rules and the Act. Staff has raised a concern about whether the proposed spacing protects correlative rights, which we affirm today that it does. Next slide. So we understand that you have had an executive session on this issue, but we want to take a moment to review the statutory definition of correlative rights. Importantly, each mineral leasehold owner is noticed of all spacing requests, and if they do not believe they have been afforded an equal opportunity for equitable development, they can petition as an affected person. For the SUMAC OGDP and spacing requests, no mineral owner objected, every mineral owner will receive their proportionate share of production proceeds. No minerals will be stranded, and no hydrocarbons will be drained across the unit boundary, thereby protecting correlative rights. Next slide. This slide shows the mineral ownership underlying the proposed spacing unit. It is owned in majority by two sophisticated mineral owners, CCRP being one of them, that will receive their proportionate share of production proceeds and did not object to this application. Next slide. What we believe staff raised in the director recommendation is whether the proposed unit will create waste. The Act defines waste in several ways. When considering waste, we must consider whether a proposed development will result in non-uniform, disproportionate, unrateable, or excessive development. We must also consider whether the proposed development will cause reasonably avoidable drainage between tracts of land, resulting in one or more producers or owners in the pool producing more than an equitable share of the oil or gas from the pool. For the SUMAC OGDP and spacing, none of these criteria for waste are met. The development is uniform, proportionate, it is not excessive, it avoids drainage across the unit boundaries, and will not lead to inequitable production. Next slide. This slide contains the statutory requirements for establishing a drilling and spacing unit. And again, the requested spacing meets the requirements of the Act because it will prevent waste, avoid the drilling of unnecessary wells, protect correlative rights, and is not smaller than the maximum area that can be efficiently and economically drained by one well. Next slide. And here we have summarized the statutory spacing requirements which the SUMAC development meets. As Mr. Ken Cooper will review with you shortly, all of the statutory requirements for spacing are met by the proposed SUMAC development. Next slide. It's also important to look at the most recent spacing order approved in the last 4 years in this area of Colorado. Just this past January, the Commission entered Order 535-1409, which established a similarly sized 1,372 acre unit for the development of a total of 4 horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. This development in sections 22 and 27, like the proposed SUMAC unit just 2 sections over, targets the Codell formation. The COGCC engineering review for this spacing application ultimately indicates that it is acceptable overall. And this January order is indicative of the more typical 4-well spacing of the target Codell formation in this area of the basin, and is consistent when taking into account nearby development. I'm now going to turn it over to Ken Cooper, who's the managing principal of Petrotech Engineering Corporation, to continue the presentation.
Thank you, Kelsey. Thank you, commissioners. I've got a few slides here that I'd like to take you through that summarizes some of the critical issues from a technical perspective that we think are germane to this decision. So to start with, this area of Colorado, as had been indicated in the earlier slides, is not yet heavily developed near the OGDP here. As of 2022, on average, there is no township yet that has a township-wide density of greater than 4 wells per unit. So that's something to keep in the back of our minds here. The proposed development plan is quite reasonable based on history, as I'll show you here in a couple of the upcoming slides. And in my opinion, prudent development would be to learn more about the area and further refine the development plan if and only if it was needed. And then I'll provide some summary of the engineering calculations and the geologic information that had been presented previously to staff last year with respect to how we documented that correlative rights would be protected and waste would be prevented. If we could go to the next slide, please. So what's happened thus far is materials have been presented to the commission that indicate that the DSU should be established with a certain size. It shows that the unit is not smaller than can be drained by 1 well. It shows that 4 total Codell wells would be acceptable to produce the resource. The unit is spaced for Niobrara, Fort Hays, Carlisle, and non-target formations. Those are non-target formations. The primary target is the Codell in particular. We show that correlative rights are protected because 4 wells won't drain more hydrocarbon volume or area than is present within the DSU. And that's one of the main issues that we're obligated to present as part of these types of proceedings. We then show that correlative rights are protected because the average drainage distances aren't projected to extend across unit boundaries. We avoid drilling too many wells such that surface impacts can be minimized, which is obviously a strategic target here. And then it also allows for development plans to evolve in the future if it's needed. Can we go to the next slide, please? So the way we've gone about doing this, just to summarize real quickly, and I won't get into a lot of the numbers, those are already provided and have already been reviewed by staff, but just generally the way we go about doing this and what we did here was we chose analog wells that are likely to be representative in the area for the development. So we look at things such as how close is it? What sort of geology do we have in the vicinity of those offset wells? The age of those wells, the lateral length of those wells, the type of stimulation, type of completion, that sort of thing. And we decide whether those are appropriate analogs to be used. Then what we do is we do decline curve analysis, and we come up with an estimated ultimate recovery, an EUR, for what sort of volume we think is going to be produced from each of those wells. And we apply that based on an economic limit. And we then take those and we normalize them for issues like lateral length. And then we calculate a drainage area based on that volume and the distance that we're likely to produce based on the hydrocarbon pore volume in each of the areas of those example wells, based on recovery factors that we've estimated, stimulation designs, and so forth. Then we also take into account what sort of uniform development would be appropriate based on offset units. So we've done those sorts of things. Those were presented in detail in these submittals previously. So if we can go to the next slide. What I'd like to show here is to give you a bit of a graphical representation that you've seen, where you can see on this slide to the right, kind of the core down to the bottom part of the slide, going up to the Wyoming border with Colorado, and then showing the Sumac OGDP of interest for today's discussions, highlighted in the light blue, and in proximity to the lighter green shaded units, which have been drilled thus far with 4 wells per stand-up in most cases. So as you can see, the vast majority of all the units in this area, anything that can be used as an offset analog, is being drilled with 4. There are very few exceptions to that. So if we can go to the next slide, slide number 13 here. This is a zoom in. So what we've done is we've just taken the same map and we've zoomed into the area that's more proximal to the Sumac OGDP here. And you can see the types of wells or well density that is present and has been drilled up in the vicinity. So there's really very limited examples of anybody that's doing anything more than 4. Almost everybody is doing 4. So the concern that exists at this point is, how do you keep things uniform? How do you protect correlative rights? And then from an economics standpoint, CCRP as an operator, I think, has justified concerns about the potential for drilling too many wells, impacting economics and also impacting the type of the type of surface impacts that would result from drilling more wells that are needed. So if we can go to the next slide. Wanted to talk real quickly and kind of give you my thoughts with respect to a summary of where I believe stranding comes into play. And so stranding is an action that results in oil and gas being left in an unfavorable circumstance that would prevent future production of that resource. I think that's a good basic definition of stranding from my perspective. And there are many reasons why targeted minerals might not be able to be accessed or stranded, including subsurface or subsurface limitations. Here on the right side, I've got a little cartoon that presents one example of how off-pattern laterals might result in stranding of the resource. So uniform well spacing and orientation that allow for future infill drilling, if it becomes necessary, are not something that, in my opinion, constitutes the potential for stranding. So if we can go to the next slide here. Future increased density, as I mentioned, doesn't equal stranding. So if you take a look at the right-hand slide here, the dark green area around the black 4-well slot drilling pattern, let's presume that that's an example of what might be happening in a particular development. Well, if that were to occur, and if in fact there was a better recovery factor and we drained to a shorter distance around the wellbore laterals than what we had originally anticipated or what perhaps would be hoped for, there isn't a stranding in this case, because what happens is you've got the ability to do infill drilling. So if you can look at the far left-hand side of that, where you've got kind of the lighter green line with the light green kind of drainage shading around it, that would then be infill drilling sometime in the future, if in fact the very limited drainage were to occur as represented by those dark green shading around those well bores. So if a well could be drilled later, if it's justified somehow to produce additional hydrocarbon, we don't have any stranding of a resource. So let's go to the next slide. So let's get more specific with respect to what's going on with the proposed Sumac OGDP that we're discussing today. Here is a figure that shows the single well that has been drilled, kind of the lighter red that comes off that True Ranch pad there, that's kind of more in the middle of the figure. And then it shows the other proposed wells in the immediate vicinity with the Sumac OGDP highlighted in green on the right-hand side. So as you can see, the thought process here and the type of development plan that is being evolved for multiple different units here is pretty uniform. And the idea of having 4 codels drilled within the Sumac OGDP is appropriate because it accomplishes a number of things. First, it accesses targeted minerals in the Codell Formation, consistent with what's going on elsewhere. We have no drainage between units. We've shown that in some of the previous materials that have been discussed here. We avoid the drilling of unnecessary wells. We allow for infill opportunities if it's justified by data that we acquire in the future from production. And again, we don't see how this ends up resulting in a stranding, and therefore we don't see how there's waste, and we avoid waste in terms of surface facilities that are not necessary. So if we can go to the next slide. So to summarize the last 7 slides I've presented to you, what we've done is we've talked about how development plans have evolved in different areas and formations within the DJ as knowledge is gained. And you can see that from those maps that I had presented earlier. We've got a fairly uniform approach up here in the north area for a 4-well density. We're still in fairly early development phases on the Colorado side of the border. And so things really aren't yet mature. And we do have the ability to do some final infill development if that opportunity did arise. We're going to allow the economics and the reservoir to tell us what it wants. I think that's pretty important with the way that we move things forward. It's always possible to add wells, so long as we don't do something ridiculous in a drilling plan, like have some very strange, irregular shaped or irregular directional laterals. We're not doing that here. This is a situation where it's a fairly commonplace approach. But I'd like everybody to keep in mind that drilling too many wells can't be fixed, right? That the impact is already there. The economic results are already kind of predetermined at that point. 4 wells using a standard stand-up pattern is not going to strand a resource, so there's no waste. Development with 4-well density is typical for the area, and it allows us to make sure that correlative rights are protected. So that pretty well concludes what I wanted to bring up. So I'll turn it back over to you.
Thank you, Ken. Next slide, please. So this slide again shows the statutory requirements for spacing, which must be considered when you evaluate approval of the Sumac OGDP, and which have all been met by the application in front of you. Next slide. The second issue we would like to address is CPW's wildlife assessment, indicating a preference for the use of an existing location. Here's the exact language out of the CPW Sumac Wildlife Assessment. And it's important to note here that CPW ultimately concludes that the Sumac OGDP is sufficiently protective of the mule deer and pronghorn habitats. Next slide. To follow up on an issue discussed at our last hearing, CCRP commits today to no longer evaluate the existing Grindberg pad for saltwater disposal. Instead, CCRP will commence plugging and reclamation operations on the Grindberg pad upon conclusion of completion operations on the Sumac pad, or 1 year from the commencement of construction of the Sumac pad, whichever is earlier. We've had the proposed BMP language here on this slide, which takes the previously agreed upon condition of approval from the director recommendation and omits the consideration of the Grindberg pad for saltwater disposal. CCRP believes that this is an important consideration as this land will be fully reclaimed by a date certain to avoid any potential impact to wildlife in this area. Next slide. So when considering the proposed Sumac OGDP and potentially developing from an existing location, waste still must be considered. The Act defines waste as not including the non-production of oil or gas from a formation if necessary to protect public health, safety, and welfare of the environment or wildlife resources. The CPW assessment concludes that it is not ultimately necessary to develop the Sumac minerals from an existing location to protect wildlife. And that is because CPW states that if the Sumac pad is used, the OGDP is sufficiently protective of wildlife. And so therefore, developing the Sumac minerals from an existing location will create waste in violation of the Act because the eastern half of the unit cannot be efficiently developed from an existing location. Next slide. CCRP also took a look at potential long-term impacts that would result from developing the Sumac minerals from an existing location. The analysis shows that using the new proposed Sumac pad will ultimately result in less impacts over time compared to developing from an existing location when you look at impacts resulting from anticipated well failures, increased traffic, and the need to expand an existing location. So if, for example, CCRP were to expand the Grindberg pad to drill 4 wells into the Sumac unit, the total surface disturbance saved would be just 1 acre, but there would be an estimated 850 more truck trips over 30 years. Or said another way, the Sumac pad adds 1 additional acre of disturbance to account for the access road compared to an expanded Grindberg pad. But CCRP estimates approximately 850 less truck trips over 30 years because it is a more efficient development plan. Next slide. CCRP also analyzed the surface impacts resulting from drilling more than the 4 requested wells off the Sumac pad and concludes that more wells on any pad will require more surface acreage, will increase drilling and completion timelines, and will result in more truck traffic. So if, for example, 8 wells were to be drilled off the Sumac pad, the footprint would need to be expanded by approximately 5.2 acres, and the duration of operations would be increased up to 20 days per additional well. In addition, truck traffic would be increased per each additional well over the life of the project. Next slide. These next several slides are the wildlife BMPs taken directly from CCRP's wildlife mitigation plan. I will not read through all of these, but will point out just a few highlights. CCRP has committed to conducting its operations outside of the winter season. CCRP will utilize a CPW recommended fence design and will reduce these fence lines after interim reclamation. And CCRP will reclaim big game habitats with native shrubs and grasses identified by CPW. Next slide. CCRP will construct its facility to minimize impacts on wildlife and will complete all 4 wells on the pad before moving its rig to another location. Next slide. CCRP will engineer its new pipelines to minimize potential impacts and will use topography and vegetative screening to create seclusion areas. Next slide. For compensatory mitigation, CCRP has agreed to pay CPW $55,000 to offset CCRP's indirect impacts to the big game habitat by operating outside of the winter season. Next slide. And finally, while construction is scheduled to begin outside of the nesting seasons, CCRP has committed to several BMPs to conduct nesting surveys prior to the construction and to consult with CPW if a species is determined to be present. Next slide. This slide summarizes the avoid, minimize, mitigate hierarchy with respect to habitat. The avoidance measures are categorized as the seasonal restrictions, as well as the commitment to plug and reclaim the Grindberg pad. The minimization measures are summarized in the Wildlife Mitigation Plan BMPs, including fencing, reclamation, facility design, and pre-construction nesting surveys. And the mitigation measures include CCRP's payment of compensatory mitigation directly to CPW. Next slide. So in summary, the sumac OGDP and spacing comply with every aspect of the rules and the act. The proposed spacing avoids waste and protects correlative rights by resulting in development that is uniform, proportionate, is not excessive, it avoids drainage across the unit boundaries, and will not lead to inequitable production. The director has recommended approval, and CCRP agrees with the 3 conditions of approval in the director recommendation, as revised to include the updated proposed COA on plugging the Grindberg pad. CCRP has an approved 1041 WOGLA permit. And in addition, through CCRP's commitment to plug and reclaim the Grindberg pad, CCRP will be reclaiming a total of 15.2 acres after the sumac pad and road are interim reclaimed. So CCRP will reclaim more land than what will be permanently disturbed through the sumac development. Next slide. This last slide is a summary of the sumac OGDP requested relief. And this does conclude our presentation. And we've got a team of panelists here and we are open for your questions.
Great, thank you. Commissioners, do folks have questions?
Mr. Chair?
Yeah, I can't see anybody, so you're just gonna have to like say,
Yeah.
hi, I have a question.
Yes, thank you, Mr. Chair. I'm wondering if staff has a response to slide 8, which is what looks like a similar approval for 4 wells in a unit that's of similar size and shape and in the same geographic area. Sorry, that's not a question for Ms. Wozlinski.
Staff?
Give us
Chair,
a
I
moment and
believe-
begin.
okay. Thanks, Mimi.
Apologies.
Sorry.
We're going to be reading staff. Thank you.
Thanks.
Good morning, commissioners. This is Sabrina Trask, the Planning and Permitting Manager. May I respond?
Yes, please.
Thank you. And if I may share a slide, please. I'll try to find the right one on my screen. Are you able to see a slide that I have that I'm trying to show?
I think so. I see CCRP slide number 8.
Yes.
Yes.
So thank you, Commissioner McGowan, for prompting this. And I might also ask that either Diana Byrne or Mark Schlagenhoff be promoted to panelist as well, since they are our engineering team who have done these reviews. I just wanted to highlight, however, on slide number 8, I feel like it's a little bit misleading because yes, the engineering review indicates that it is acceptable overall. And this is in regards to the spacing, not the spacing being considered under this OGDP, but the spacing that is referred to just a couple of miles to the west of the proposed location. That engineering review also indicated, and I'm just going to read a quote here that's on the bottom of my slide, the proposed drilling of 4 wells will not fully drain this 1,372 acre unit, and consideration should be given to additional actions such as reducing the acreage. So I just wanted to point out that although in CCRP's slide number 8, they did correctly indicate that the engineering review indicated acceptable overall, there is another note in that review that specifically mentions some concerns related to underdevelopment of that DSU as well. I think that is relevant because it parallels very much the spacing that is being proposed in the SUMAC OGDP. And I'm not sure if either Diana or Mark are available to speak further to that.
So engineering manager Byrne is in the hearing. And she is a panelist. So Ms. Byrne, if you are able to show yourself and speak, that would be helpful.
As I'm showing myself. Yeah, so I'll echo what Sabrina said. The testimony that's been provided indicates that the spacing is, it feels like it could be diminished. And it's, the engineering testimony is consistent in both cases, that while that seems to be the development plan that's being utilized north of this proposed project, that the science, the testimony that's provided does look like that is not completely draining and not over draining either, true, but that the spacing may be more appropriately downsized. The slide with the potential infill seems to speak to that, actually, that the potential for infill drilling would seemingly have to be supported by testimony also.
And if I may, Chair Robbins, I'd like to share my screen one more time. Hopefully, again, I can find the right slide. Let me know if you can see a single slide with some red and black text on it.
Yes.
Thank you. This is just a snip from the statute under subsection 1B. It is the intent and purpose of this Article 60 to permit each oil and gas pool in Colorado to produce up to its maximum efficient rate of production. And so I understand that the statute, the act, primarily focuses on there should not be overdevelopment of a DSU. But I'm just wondering if, I guess staff is looking for some indication from the commission as to how we might interpret this portion of the statute that seems to imply that the purpose of our permitting should be to produce up to the maximum efficient rate of production. And my understanding of the engineering testimony, which admittedly is not full because I'm not an engineer, but is that the 4 wells proposed in the spacing that is proposed for this OGDP is not seeking the ability to produce up to the maximum efficient rate of production for this DSU. So looking for some clarity, some interpretation from the commission today, if possible, so that staff can be consistent with our interpretation of this particular process going forward. And I appreciate any guidance you could give us. Thank you.
Mr. Chair.
Yeah, go ahead, Commissioner McGowan.
Thank you, Mr. Chair. So I'm very appreciative of staff bringing up this concern or, this issue to the staff. It's one that we haven't really dug into very much before. And from my perspective, from this commissioner's perspective, I'm not sure we're going to have like a one size fits all direction for staff. I think it's kind of going to be for me, a site specific basis and an explanation from the operator as to how they came up with the spacing unit and then the number of wells and how they perceive an efficient development of the minerals. And so I'm really glad that it was brought up, and I'm glad we've had the conversation, and I feel like the operator's done a good job responding to the concerns from staff, which I think are legitimate and valid. I'm appreciative of the explanation that the mineral owners are savvy than just someone who inherited Grandpa Joe's mineral, development rights and might not understand what they're getting or not getting. I'm appreciative that they are going to offset by reclaiming the third site. I think that that's important. I think the other piece to this concern from what I heard from commissioners was the wildlife perspective and habitat, and kind of this site that just felt like it was sitting there for whatever reason. And so, not that this is going to be satisfying for staff. This might just be conversations we're going to have with operators as we move along. I don't feel like at this point I have like an overarching umbrella thought about when we're underutilizing or underdeveloping mineral rights versus overdeveloping. So thanks to everybody today, was helpful.
Commissioner Messner.
Thank you, Mr. Chair. Thank you for the presentation and the additional information provided. So I do have a question for Mr. Cooper. I think what I'm hearing you testify to is the fact that it is possible that 4 wells will not drain this spacing unit to its fullest extent, and that if economics determine that there needs to be additional wells in order to meet that obligation, then the intent should be to enter into a pre-production mode and drill additional wells in order to be able to fully meet the obligations to drain the resources. Is that what I'm understanding?
Yes. Yeah, that's a good summary of the thought process that I think is appropriate and that I had presented. Correct.
Okay.
So I point out, Commissioner, that the nearest offsets and the nearest development that has taken place, and rigs have come in, they've drilled wells, they've moved on. It is a 4 well density at this point north of the border for the vast majority of the units that are being developed there. So is it possible that that is the right number? Yes, it's entirely possible that that is the right number. And our primary objective was to show that we were not going to be draining more resource than exists within the unit. And so there's going to be some things that are learned as that moves down to the south. And so I think the opportunity to produce, to learn, and then to adjust to wring more out of that rock if we can, would be great. But again, I don't know too many operators that in this circumstance are going to be excited about drilling 8 wells on a unit when most of the other nearby offsets are 4.
Thank you for that, Mr. Cooper. And so I guess my follow-up question then would be to the operator, understanding that this testimony that's provided by Mr. Cooper on behalf of the operator is indicating that it is very well possible that we're going to need to be able to, you would need to be able to come in twice to this location in a situation that would create twice the potential service impacts associated with operations. How is that contemplated in the plan that you're providing at this point, this additional impact that would be associated with pre-production activities occurring twice in a sensitive receptor area?
Thank you, Commissioner Messner. I'm happy to answer that. The application in front of you today is for 4 wells on the new Form 2A. And so if the data would justify it, and CCRP were to decide to pursue additional wells, which, as Mr. Cooper testified to, is rather unlikely, we would have to come before you again. We would have to file a new OGDP application, a new Form 2A, amend what's been presumably approved, and you would get the chance to review all of those associated impacts from additional wells. So today before you is a plan for 4, and if the data justifies it, we acknowledge that that's a new application that will be noticed, that will be come to you for a hearing, and if there are concerns at that time, that would be the appropriate time to address them.
I mean, I appreciate that perspective, but at the same time, this appears to be a known quantity that could be addressed in this OGDP without having to string this along in multiple OGDP reviews, because I think as we look at things, we need to look at things holistically and comprehensively, and doing kind of leapfrog or string along type development seems problematic from fully understanding what the potential impacts are to the different sensitive receptors associated with this particular application. And so it seems problematic from this commissioner's standpoint to have a known possible issue or a known element that may need to occur not being contemplated in this particular OGDP as we review potential impacts to wildlife, potential impacts to truck traffic emissions, cumulative impacts, and the associated things that are evaluated in an OGDP. And so I'm struggling with that a little bit, to not fully analyze the potential impacts of this particular operation within this OGDP rather than an anticipated second OGDP.
And thank you, Commissioner Mesner. And I think I would respectfully disagree with this being a known quantity for future development, because it's not. Today we have support for 4 wells. 4 wells meets the intent of the act, of the rules, will not create waste, will not lead to inefficient development. Every mineral owner will get their proportionate share. We're reducing surface impacts, and that's the plan in front of you. I think the point of talking about infill is when you're talking about a potential for waste, there is always an opportunity to come back in, but that's a new application, and that's not what we're proposing today. Right now, CCRP intends to come in 4 wells, 1 rig occupation, stay out of the habitat window, and it's a protective plan. So I think the future is unknown, and I think the data that Mr. Cooper presented shows that. The development is in majority 4 wells in this area, and likely that's where this will end up. And so I think the point of showing what the infill is to address any question on waste or leaving hydrocarbons in the ground or not getting to your maximum efficient rate of production. But what's before you today does those things based on the data we have now. And I'll just reiterate again that you will have the opportunity, if an application is filed, to fully review that. And CCRP understands that may lead to too much impact on wildlife. So right now it's 4 wells, and that's what CCRP thinks the data supports.
With each passing month, it appears that there's more being done to the north that is in fact the 4 well density. So the work that's ongoing is likely to start moving the science that direction. There would be quite a bit of an experiment, in my opinion, saying let's do 6 or 8 or whatever on this particular DSU at this particular time. Further, I'd like to point out that there's an issue where, from an impact standpoint, we do end up having the benefit in the unlikely event that additional incremental wells were to be justified and might be drilled in the future. We don't have surface impacts associated with surface equipment to handle a peak volume of fluids in production. We would have facilities intended to manage the production from 4 wells. There would be decline from those initial 4 wells. And if in fact there ever were additional incremental wells drilled from an infill perspective, those same facilities could then be used for the additional production. So you wouldn't be doubling up on additional surface facility impacts that otherwise probably wouldn't be necessary.
Thank you for that. I mean, I would also acknowledge that different facilities put in place, understanding what the necessary well count needs to be in order to fully drain the unit, could be contemplated, and you can minimize and avoid impacts associated with those. And so I did have one question about some of the development that was to the north, because at least in your diagram, it appears that that's not horizontal development, but diagonal development. Is that what I'm seeing there? Or?
Yeah, I should clarify perhaps. Those are relatively simplistic maps. They are in fact horizontals, and they are laterals that are perpendicular and parallel to the boundaries of the units. The ease of pulling the data out of the Wyoming system is that you get a latitude longitude for the surface location, and you get a latitude longitude for the bottom hole location, and then it just simply connects those 2 dots with a straight line. So those are a little bit misleading. If you look at them in terms of it being an actual full directional survey, they are not. They actually are laterals that are running straight down the, the stand-up boundary, parallel to the stand-up boundary of the units. So they are not diagonals. They are in fact laterals that are all parallel to one another.
Okay, thank you for that, Mr. Cooper.
Mhm.
Shifting here a little bit, I do have a question about how you came up with 850 additional truck trips associated with utilizing an existing pad. As at least it appears to me that at least the Grinberg pad is closer to the access road than the proposed pad.
Thank you, Commissioner Mesner. I believe Nate or Joe may be able to answer this, but the additional truck trips are associated with the well development not being as efficient because you've got a longer step out. But Nate or Joe, if you want to weigh in here.
I can talk to that. So I looked at, again, if you guys recall those 2 wells that we've got, we talked about 2 weeks ago that are couple miles to the east of us that we're using as examples, where one had a nominal step out and then the other one had a 3,000 plus foot step out. Using that data, right, I looked at number of failures per year and over the course of 30 years, and I did normalize this for production, right? So as you produce the well less over the later half of the well life, obviously less barrels per day, less strokes on a pumping unit, et cetera, right? Your failures are going to space out more compared to early in the well's life. So that was considered. But when I compare to those wells, right, which are analogs to what we're doing on the Sumac, I show about 14 additional failures for the long step out well. Anything over that, 3,000 feet or so. So that's 14 additional failures over the course of 30 years. And then just looking at a typical workover operation with your hot oilers, your hydro testers, your rigs, your water haulers, your pickup trucks, your gooseneck trailers, et cetera, right? Totaled up all those round trips and then multiplied that by 2 wells, because we would have 2 wells on that Sumac that would be pretty long step outs that would likely see those increased failures. And that's how I ballpark that 850 extra truck trips.
So you're basing these purely on anticipated failures, the truck trips?
Well, yeah, because I mean, the wells aren't in the ground yet, but it's based on actual wells that we have been producing for several years out there, right? The failure trends on those, one being, I don't remember the numbers, 1,418 foot, and the other one 3,500 foot. And so that's using real actual data. I mean, I couldn't find a better example anywhere else, right? It's 4 miles away. It's the same formation. It's on the same road, same depths. And the step outs almost mirror exactly what we'd be doing on the from the Grindberg location. So looking at that data, right, is about the best I could give you.
Okay.
And I'm just projecting that forward, right, for 30 years then.
And then one other question, because, understanding that at least my understanding of this is that there's gas takeaway, but there's no oil takeaway. And so the oil takeaway will be provided by trucks. And understanding that you're proposing timing stipulations for pre-production activities, but not for production activities. And so I think I heard from the last hearing, and I'm just confirming this, that you're anticipating about 12 truck trips a day associated with the ability to take product off site. Is that right? At least I understand that there's a decline curve and over time it will be less, but initially, are we looking at 12 truck trips a day?
Yeah, so you'd be looking at initially for 3 wells, you would have 10 to 12 oil truck trips per day, but then after a year, that would go down to 2 to 3 per day.
Okay, thank you.
Chair,
Yes, go ahead.
thank you. I appreciate that. And thank you for the presentation today. At the previous hearing, I expressed some concerns about pushing this development further to the east and north into significant high priority habitat, and do appreciate the comments that were made today. I didn't see any significant new information to address those concerns, but really just kind of a restatement of comments from the previous hearing. So as has been talked about, the mitigation hierarchy is to avoid, minimize, and mitigate. And I think it's important to note that the regulations aren't set up to provide a choice or a menu between avoidance or minimization. In this case, using an existing pad in already disturbed and partially constructed location, and mitigation, which in this case would be expanding development away from the road and farther into minimally disturbed high priority habitat, and with a mitigation payment and further mitigation potential payments if development activities take place during certain times of the year. Rather, they're set up to be a structured, progressive approach to only allow for the less desirable mitigation scenario when the preferred more desirable avoidance or minimization scenarios aren't feasible alternatives. And so when looking at CPW's comment, it's important to understand that CPW is not a technical expert in drilling operations, and they understand that our regulations are set up to allow for a potential mitigation scenario. And I think their comment must be read in this context. Their stated preference for an existing pad recognizes their preference for avoidance and minimization over mitigation if possible, but understanding that our regulations do allow for a mitigation type scenario, they've also explored and approved an appropriate and acceptable potential path in the mitigation scenario if the avoidance and minimization scenarios are not possible. So to me, this really kind of rests a lot on the technical difficulties associated with the step out that the operator has expressed concerns about here. And admittedly, I'm not an expert on step outs either. I would be, Mr. Chair, interested in hearing from staff regarding the frequency of operations, working with step outs of distances around 3,000 feet, and want to understand if that's a common step out distance, or would this be a rare occurrence if step outs were to be 3,000 feet, or I think it was 3,400 feet.
Someone from staff desire to try to respond to Commissioner Ackerman?
This
Ms. Byrne?
Diana Byrne. And again, it's development down in the DJ, but that is not an 100 rev step back by any means. And there are many, many, many that are way more than 3,200 feet.
I appreciate, thank you, Ms. Byrne. I appreciate that. And so I think it's important to note that my concerns remain associated with building a new pad deeper away from the county road, into relatively undisturbed habitat, aren't really mitigated by the presentation today. And I don't know if the operator has any comments to address any of my comments today.
Operator?
Thank you, Commissioner Ackerman. And we appreciate your comments and do understand deference to CPW in terms of protecting wildlife. And I think it's our position that our plan before you does still protect wildlife. The commitment to plug and reclaim Greinberg, I think, is significant. In addition, I think it's really important to still look at that definition of waste. CCRP has testified that it will not be efficient to develop this unit from an existing pad, thereby leading to waste. And waste is not leaving hydrocarbons in the ground if it's necessary to protect wildlife. And why we pointed to the CPW wildlife assessment is that while it does state we prefer use of an existing location, if the operator or the commission were to approve the sumac pad and the operator moves forward, it will still be protective. And I think that's really critical because it's not necessary to protect the wildlife resource to develop from an existing location. And so with that and reading the language of the act and the definition of waste, we believe that developing the unit from an existing location will create waste for all the reasons we've presented to you. And so that's our perspective on it. This is a protective plan. The BMPs are considerable and we understand the allowances in the rules. And we do believe that the location is and entire development plan holistically is protective.
Thank you, Ms. Wasilewski. I appreciate your response there. If I could just kind of elaborate on one of those points. And the point was that waste would be created because the development could not be done from the existing pad, but we just heard from Ms. Byrne that these are very common step out distances. And so I'd be interested in hearing from the operator what is special about this scenario that these common step out distances could not be achieved in this instance.
I can step in there briefly, and we're by no means saying that we can't drill a well with these step outs. It's certainly technically feasible. You know, we talked about that a little bit 2 weeks ago, but what we were trying to illustrate today is that even though it's technically feasible and people do it all the time, right? We're trying to present to you data that shows there is a consequence of doing that you're gonna feel for the life of the well, right? Because you are gonna suffer incrementally additional failures, right? I can't tell you, you know, I tried to illustrate based on offset wells and using that data to forecast forward that it was going to be 14 additional workovers, right? Over the course of 30 years, it might be 20, it might be 12, right? But there are going to be additional workovers. And what we're trying to illustrate is that every time there's a workover out there, right? It's a rig, it's truck traffic, it's disturbance in the area. And surely that's disruptive to the habitat. And a lot of times that's not between, you know, May and November, you know, that happens year round, right? So you could have trucks on the road there in the winter, November, December, January, February, right? Dealing with those issues. So we're saying if there's a location where we can avoid disturbing for the life of the well with additional truck traffic, right? That after we reclaim the Grindberg is within an acre of size, pretty close in that habitat. And then we can take all those trucks off the road and make sure that the wells drill easier. We get the minerals from the start, right? Land in zone, all those benefits, right? Why would we not choose that as the operator, right? So that's the point I'm trying to make with the truck traffic, right? Yes, it does push it east, acknowledge your comment there, but we're taking away habitat and then we're keeping over 30 years, which is a long time, we're keeping a lot of trucks off the road by just making the wells easier to produce. So.
Thank you, Mr. Krzyzewski. Appreciate your comments there. And I think one of the important things to understand also about the habitat is that, you know, it is important to reclaim the habitat, and you're talking about habitat that would be then in between two developments as opposed to pushing the entirety of the development further to the east. And I think, you know, from my perspective, the 1 acre direct disturbance is not necessarily the issue. It's the indirect buffer disturbance associated with moving the entire development further away from the county road and further to the north and further to the east. And while you may have additional truck trips drilling from the Grindberg pad, they would be along an already disturbed and existing county road, as opposed to, you know, a 3/4 mile spur road up into important 3 times over high priority habitat. And so I'm having a hard time getting over the hump of you know, which of those is the greater difficulty. So I appreciate the comments, and that's all I have. Thank you, Mr. Chair.
Further questions for the applicant?
Yes, Mr. Chair, I have just a couple because I think most of my questions have already been addressed. And I want to talk briefly again about, I guess probably the best slide to look at is slide 4 from your new presentation here, where it talks about the actual oil and gas lease ownership. And one of the questions I wanted to ask is, do you still find it to be your belief that if you were to go from the True or the Grindberg pad, that you probably would not drill the easternmost well?
Nate or Jesse, do you want to answer that question?
This is Jesse here. I can answer that. And the answer is yes. I do not think we would drill that easternmost well. Whereas the sumac where it's placed right now, we would see full development of the DSU with equidistant spacing between well bores. If we were on the east side or the west side on the Grindberg or the True Ranch pad, I do not see that being the case for the full.
And how would that affect? So looking at slide 4, where you have the different the mineral owners listed, and how would that affect the correlative rights if you don't drill that easternmost well?
Commissioner Cross, I'm happy to take that. And maybe we could bring up slide 4, Justin, if that would be helpful. So when we look at correlative rights right now, developing from the sumac location protects correlative rights because you have uniform development. And thank you. If you were to leave the hydrocarbons kind of in place on this eastern side, then I think, right now we only have 2 mineral owners plus some fee land up in section 24. But if, for example, there were different ownership, perhaps a mineral owner could argue that they're not being drained and that they're sharing in production in the larger unit. And perhaps that would mean an additional surface disturbance to equally develop the entirety of the unit and to come into that eastern side. But that would have to be likely done from another surface disturbance. So, it's co-equal opportunity to production is how I look at correlative rights.
Do you think that the other mineral owners are going to be, would that indicate that the other minerals owners are not getting their fair share of what's actually being drained if the far eastern well is not being drilled?
If no well is drilled on that far eastern side at all, meaning it's not accessed from another location, I think it could be an argument that there's a kind of disproportionate withdrawal of minerals within the unit, and a mineral owner could certainly try to make that point.
And so I guess building on that, has that situation in talking to some of the mineral owners, some of the landowners, et cetera, because I understand that no mineral owners have complained about the idea of a 4-well density here as opposed to an 8-well density, but has the idea that far eastern well may not be drilled if the sumac location is not used, has the idea that only potentially the western 75% of the DSU will be drilled, has that been explained to mineral owners?
I can have Jesse weigh in here as well, but I think that answer is no, just because what was proposed in the application, the spacing and the OGDP, was development from the sumac pad, which CCRP can support as protecting correlative rights because it is, proportionate, efficient production. And so I don't think CCRP explored alternatives with those mineral owners and kind of other development scenarios, but Jesse, I'll let you confirm that.
Kelsey, your answer is correct. The only other alternative scenarios we looked at, determined to not be viable, and a sumac is what was discussed and proposed.
And then I'm gonna preface my next question a little bit, because I don't want to say in asking this that in any way I think it's appropriate or support proposing extra wells beyond what you intend to drill or anything else. But I guess my biggest question in looking at this, understanding that other wells and other DSUs have a 4-well density in the area, but if there is the potential of you coming back, and if it's economical, if there is the potential of coming back, why not at least do an 8-well DSU, knowing that likely would or could drain it, and then only drill what you economically think is correct?
And thank you, Commissioner Cross, and I'm happy to answer that. I get really concerned about setting that precedent. I think it's not.
That's why I prefaced it.
Right. I think it's not transparent. I think CCRP has the technical evidence to support 4. They've designed their pad for 4. Frankly, I think trying to over permit something, not only will that create more surface disturbance, but it just doesn't paint a transparent picture of what's actually going to be developed based on the science. And I do get worried about setting a precedent or an incentive for operators to over permit locations to avoid a conversation like this. I think it doesn't comply with the intent of the act or the commission's rules. And so I think right now, there's a reasonable, efficient plan before you that CCRP really does support, and the development in the surrounding lands really does support. So that would be my answer to that.
Thank you, Mr. Chair. I think that's the only questions I have.
Other questions?
Mr. Chair,
Go ahead.
I'm wondering if CPW is still with us today and if they have thoughts about the updated proposal from the operator. And then I've just been thinking about Commissioner Ackerman's questions and wondering if CPW has some opinions about, 850 additional truck traffic trips, which is something like 2 per month for the life of the well, if we were to use the existing pad and the step out, versus reclaiming an existing site, but then moving into this new area.
And Mr. Chair, Mr. Murrat from CPW is with us and available to address that question.
Thank you for the question, Commissioner McGowan. And for the record, my name is Brandon Murrat. I am Colorado Parks and Wildlife Northeast Region Energy Liaison. And so to get back to your question, Commissioner McGowan, and to make sure I'm clear, the updated proposal, I would like to be refreshed on that. I've been following along this morning, but I want to make sure I am super clear on the proposal at hand.
Thank you,
So
Mr.
whether-
Moran. I'm happy to address that if appropriate.
Go ahead.
Thank you. CCRP is proposing to submit a Form 6 to plug the existing Greinberg well and to fully reclaim that existing location, which I believe has been referenced as alternative number 2 in our materials prior to this hearing. And so that would be done by a date certain via a condition of approval on the Form 2A. And will no longer consider using that well as saltwater disposal. That location will be plugged and reclaimed.
Great, and that's what I was believing the proposal was. I just wanted to make sure. And so, again, I'm stepping out past my expertise, but if the injection does not happen near the L2, would it happen on the Sumac location?
No. Nothing in this proximate area would be considered for an injection well. So
Okay.
that proposal was to use the, I believe it was just surface casing, to use that well and permit it as injection. And now the commitment is to fully plug and reclaim. So there will be no injection well in the unit or in the vicinity.
Okay, and yeah, and I appreciate that. And so, and when I was looking over and listening to the hearing this morning, was an alternative explored? I pulled up your ALA map, but whether it was from today or last hearing, I don't know if I necessarily heard a alternative for Sumac being, say, 100 feet just north or even closer to the county road. Was that an alternative that CCRP explored?
And just to make sure I'm clear, would that location be in Wyoming?
I'm sorry, so 100 feet. So right now the proposal is to go, what, a mile or a half mile north of County Road 136 to where it is, it abuts the Wyoming border. I'm talking a half mile south of the Wyoming border, so it's adjacent to County Road 136. Was that explored?
I can answer that
Thank you.
question. The topography south of this pad is really rough. The disturbance would be significantly larger, if not double. So
Okay.
It was visually explored, but not surveyed or anything beyond a visual aspect.
Thank you for that, Mr. Martin. And so to get back to your original question, Commissioner McGowan, obviously, and Commissioner Ackerman alluded to this earlier, it's CPW's first preference to avoid HPHs. And so that's when I received this application, that's the first thing. Is it feasible for them to avoid that? Obviously, no, it's not technically feasible for them to develop it outside of, to access this DSU from outside the high priority habitat. And so, then you still have alternative 3. The thing, and Ms. Wazlinki, if we can bring up the slide that shows the the wells, how you guys were using it for illustrative purposes for the 4 well density. I wanted to speak to that from a wildlife perspective. And so while they're bringing that up, what I'm trying to do as far as, you know, the pronghorn, especially this time of year, like how it's snowing today, you know, how, especially if it's more heavier snows in Wyoming or whatnot. So not that slide, but let's see.
I believe it may be slide 16. Yep.
The one or two before it, where we show the Wyoming, how it's mainly green. One more, keep going. Yes, that one right there. Let's stop on that one. So obviously CPW is, you know, our mission is to take care of the animals that are in Colorado. But when we look at this landscape level scenario, you do have pronghorn that are in Wyoming that could cross the line and come into Colorado. And then, you know, after that point, obviously, they are CPW's responsibility. I did try to text the big game biologist for that area to ask if Wyoming collared any pronghorn, but that remains to be seen. I keep thinking about the childhood game red rover. And the one thing we don't want is to create several working pad surfaces on the landscape that pronghorn have to navigate to get into Colorado, especially wintering pronghorn. And so that's a long-winded answer of saying that, yes, they can't avoid the HPH. And so, you know, given that they are reclaiming that well to the, just to the west of that, and obviously reclaiming it, it's not going to automatically match the adjacent habitats. It obviously COGCC has their reclamation standards that have to be met, and CPW has recommended pronghorn seed mixes that we can recommend with landowner approval. So there will be that time frame, but you know, that being said, you know, it's that, yes, it is sufficiently protective of wildlife, but at the same time too, I want to highlight during the presentation how they bolded CPW's wildlife determination in a different manner than I bolded it when I originally sent it. So given that one of the existing pads is now off the table, I guess I would want to double check with CCRP as far as that further west one. And I assume their answer is going to be it's not technically feasible to drain the DSU, but I would like to explore that before finalizing my answer for Commissioner McGowan.
Thank you, Mr. Moret. I'm happy to have CCRP talk about the True Ranch location, which is the other alternative.
Correct.
Which is further to the west. So perhaps Nate or could talk about the step out distance there and what that would mean for the eastern development.
Yeah, if you look at the, I'm looking at a map here with some approximate step out distances. You know, if we were to look at drilling, I'm going to do some math real quick in my head, drilling the easternmost sumac lateral from the True Ranch 2326 pad, which sits in the next DSU over. That's the one I think we're talking about. You know, you're talking, have this up real quick. A step out of, you know, over a mile, probably 6,000 feet, 5,900 to 6,000 feet. And then the next closest lateral, the middle one on the sumac pad, you know, that would be still over a mile. That would be around, you know, right around a mile, 5,200 feet. So really long step outs there. Does that answer the question on step outs? And we would certainly not be comfortable drilling those two. And then it even brings to question the third sumac lateral, because that ends up being pretty far step out as well. Almost around 3,000. So you end up with three really, really long step outs.
Thank you for that response. I was assuming that would probably be the response. And then can you go to the slide that talks about the other spacing that is further to the west? That was the first that I've heard of that, and I assume that one is also in high priority habitats. Is that for pronghorn? Is that accurate?
And Mr. Moret, I believe that's slide 8. This isn't only subsurface spacing, so it is not proposing the order was not involved with a new Form 2A. That was using an existing Form 2A with a spacing request, which was approved in January.
Okay, and so the existing 2A was previous to January 15th, 21?
I would need to look into that, unless Jesse, you know that.
Yes, it was.
Okay, thank you. So back to Commissioner McGowan. Yeah, given the remaining alternatives on the table, or I guess just the one preferred location, and CPW does appreciate that this is being proposed to be constructed outside the pronghorn winter season. We can discuss whether, truck traffic should be reduced, but obviously that's based on, what is being produced. But it would be good for CCRP to double check and see if there's a way to minimize truck traffic during that first year. That sounded like it was pretty high on the landscape during those winter months. But given that, and Commissioner Ackerman, unless there's anything else you want to chime in about, then CPW believes that the remaining preferred location is sufficiently protected, given that we've explored all the other alternatives.
Further questions for Mr. Moret?
I have another question, Mr. Chair.
Go ahead.
And I want to explore the Greinberg change from the potential injection well into now plugging and abandoning it. Would there be, if it was to be used as an injection well, how would that change the truck trips for produced water?
It would certainly reduce it, right? That was one of the benefits. You have the sumac and the True Ranch pad there. And so it would reduce the total length, right? You would still either have to truck it a couple 100 yards, or we could put a little pipeline system in there long term. It would take the trucks off the road going the whole length into town.
Okay, and Mr. Moret, it might be helpful for this as well, because I'm just wondering, with the Greinberg being as close as it is to the existing surface access road, I'm almost wondering if the benefit of less truck trips from having an injection well is better than some reclamation of an existing pad that is right by an existing access road.
Yeah, and if I'm sticking solely to the pronghorn perspective, I'm not only looking at sumac or even the Greinberg pad itself, but I guess I would probably ask CCRP, for this injection well, is that going to be on the landscape, indefinitely, or is the plan just, for 3 years, or what would be the plan with that scenario?
Jesse or Nate, do you want to answer that?
You want to take that one, Nate?
I'm sorry, could you repeat the question?
Sure, assuming I understand Commissioner Cross's scenario, if we keep that alternative 2 just to the west of the proposed sumac as an injection to help reduce truck traffic to and from Sumac. How long would that injection well be on the landscape before alternative to the Grenberg is plugged and abandoned and reclaimed? Is it on the shorter end, or would it be on there indefinitely on the same time frame as Sumac for whatever 40 years or however long the?
Yeah, I think we'd assume it's the latter, that it would work in concert with the production out there. So, 20, 30 years.
Okay.
Yeah.
Thank you for that answer. So Commissioner Cross, to get back to your question, what I'm balancing in my head as far as, obviously there's a new proposed pad that's being located, and we want to make sure that any wintering pronghorn that normally, migrate in the wintertime down to Colorado from Wyoming have the ability to do so. And the more pads that are on the landscape, especially given, given the indirect buffers. Obviously, you have the direct pad itself, but also, you have human activity, noise, and if there's any lights, those add up. And so there's these almost like how you see for buffers for raptor nests or grouse leks. There's those buffers. A similar buffer can be associated with the indirect disturbances with these locations, whether it's the noise or whatever. So when those adjacent pads are near each other, they can merge into one. So it could be like an effective wall, even though there is habitat between both of them. And so that's what I'm balancing in my head as far as the best avenue forward. And yes, we do have truck traffic. And so that's sort of a long-winded way of saying, I'm not necessarily sure if, keeping the injection well in the landscape or not to reduce truck traffic is the best alternative or not. I think I'm still debating that in my head right now.
And just for clarity purposes, so I'm understanding correctly, big picture, the surface disturbance is going to be the surface disturbance along with the timing stipulations is going to be a bigger benefit for the pronghorn than reduced truck traffic.
Could you repeat that, please?
So the idea of doing less surface disturbance by reclaiming the Greinberg pad, along with the timing stipulations of not drilling, doing the production or the completion activities, et cetera, during wintering pronghorn season, those factors together are going to be a bigger beneficial impact than reducing truck trips.
That's where I'm landing. Yes.
Okay. I just wanted to make sure that I understood that. Okay.
Thank you.
And that's one of the things that I really wanted to understand is because there could be benefits from an injection well, but if it's more important that the actual surface disturbance is more important, then I just wanted to verify that. Thank you.
Absolutely. Thank you.
Further
Mr. Chair,
questions?
I've got a question for Mr. Moret. So Mr. Moret, I guess I'm a little confused. I guess it was my understanding that there was a benefit from CPW's perspective to utilizing existing pads generally to minimize surface disturbance associated with new operations. And this was particularly critical in high priority habitat areas. And that was the alternative that was, generally speaking, from CPW's comments, the preferred alternative is to utilize existing pads. Here we've got a proposal now that I'm hearing, I think I'm understanding your comments from, where we're proposing a new location with associated disturbances, and then disturbances associated with plugging, abandoning, reclaiming an existing facility, which creates additional disturbances. The new facility, proposed facility, is further away from the county road, the main arterial road. The anticipated early truck trips associated with the new operation are around 12 per day because of the production curve associated with not having oil takeaway and having to truck it. which doesn't create an opportunity to minimize the truck trips associated. We've got the construction traffic associated with it on the new pad. And that's, in your mind, more preferable than the utilization of an existing pad from CPW's perspective? Because to me, this is different than what I heard you say at the last meeting or in previous OGDP reviews. So
Thank you for the question, Commissioner Messner. And I think what you are hearing is a result of me listening to the hearing. And yes, my first preference is that this location would not be in high priority habitats. That's my starting point right there. But that is not a feasible option on the table. So then we go to more of the minimization measures. And yes, per my email, it is still more preferable for this development to occur on the Grindberg or another existing location for the reasons you spoke about. It's closer to the county road, it's existing disturbances. You know, we don't need a third location within roughly a mile of each other, you know, that would, you know, could act as a direct and indirect, you know, merged buffer for pronghorn coming to the south. And so I think what I'm trying to provide the commission is that, okay, if developing alternative 2 is not a location, how does CPW feel about the sumac? And so to your point, Commissioner Messner, it's my preference that this doesn't happen in pronghorn habitat. That's number one, avoidance of the HPH. And number two, it's my preference that it happens on an existing pad, but that doesn't sound like it's a feasible option from an engineering perspective, or maybe that is, and maybe that's the direction the commission wants to take. But yes, my original email still stands. And like I mentioned in the last hearing, that I would rather use an existing pad on the landscape, even if it has to be expanded a little bit. The pronghorn are used to those truck traffic, to human activity, to that disturbance there versus a brand new pad on the landscape. But it sounds like, based on this conversation, trying to get wildlife's perspective on the proposed location, because that seems to be the issue at hand, unless I'm not answering the proposal on the table is that what everyone's getting at, as far as obviously the sumac is the least preferred option, but if that's the option that the commission prefer or chooses to go in that direction, yes, I have worked with CCRP to develop various avoidance, minimization, and mitigation measures. But yes, my preference is to use an existing pad.
thank you, Mr. Murat.
Further questions for Mr. Murat or the panel? All right, I'm seeing no further questions.
Mr. Chair, you're on mute.
Seeing no further questions, I am gonna call for a 10-minute break. I'm gonna try to get back to my computer for deliberation so I can see everybody. So let's return at 11, let's say 11:50. That's 13 minutes. Okay, can folks hear me and can you see me? Okay, lesson learned, do not spill orange juice on your state issued laptop, because you then will be issued a new state issued laptop, which none of the features are set to go. So apologies for all that, folks. All right, we are back live. I can see everybody. This is fabulous. I'm not on an iPhone. We finished questions for the panel. Ms. Wazelinski, before we move into deliberations, did you have anything further? There was a lot of questions.
Thank you, Chair. I did just want to clarify a couple very brief points. First being that if CCRP were to develop the proposed unit from an existing location, being Grindberg or the True Ranch, they've affirmatively confirmed that they will not develop those easternmost well or wells. And the concern there is the creation of waste. It would be inefficient and uneconomic development, and it would harm correlative rights. And then the second point I just wanted to make sure we all were clarified on was that if an existing location were to be used, that location would still need to be expanded in the habitat area. So just want to make sure that we're clear on those points, and I'm happy to answer any other questions, and the team is still here and happy to answer questions as well.
Okay, thank you for that. Commissioners, are we ready for deliberations on this permit? All right, we've got the folks still around. If deliberations make folks have questions, does anyone want to deliberate to begin? Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate that. Appreciate the opportunity to share some thoughts here, and appreciate the operators' work and their responses to the concerns and questions that we've raised. With regard to the number of well bores, I just wanted to state that I really do support and appreciate the operators' approach of proposing the number of wells that they realistically expect to drill. I think that's a great approach and really appreciate that. It is a bit difficult for me to base the reason for 4 wells simply on the fact that that's how it's being done in the area. I would have preferred to have seen more engineering testimony and substantiation scientifically of why that's the most appropriate approach. And I do think further engineering would be helpful for more efficient and precise production and protection of correlative rights on this issue. But that said, I can support the development of 4 well bores. I do acknowledge and share staff's concern about there being potential for more efficient development. And while this approach, in my opinion, as articulated well by Ms. Wazelinski, does not technically and legally constitute waste, I worry that it's an approach that emphasizes early, easy, heavy initial production while potentially leaving significant resources in the ground. And that's to say nothing of the creation of the potential for additional disturbance to wildlife if a future, complete interstitial well space drilling plan is proposed. But that said, I do believe that it meets the requirements of our regulation, and I appreciate the articulation of that today by the operator. With regard to the sumac pad, as I stated, my concern is not simply 1 new acre of direct disturbance for the road and the sumac pad. This proposal moves development away from the already disturbed county road, away from an already constructed pad that is already near another pad to the west, pushing development 3/4 of a mile deeper into, as I said, three times over high priority habitat that is currently insulated from the county road, and other development by topography is a heavy concern. The indirect disturbance of that'll create, coupled with the proposed sumac pad being on the far east end of the area development, effectively and functionally pushes wildlife use of the habitat entirely east. In the end, if disturbance can be avoided, it should be, plain and simple. If it cannot be, rules are set up to allow for development in HPH with an appropriate mitigation plan. In this case, I believe it is reasonably feasible and commonly done to step wells out at distances that could be achieved from the Grindberg pad. And from my perspective, that approach isn't off the table, as was assumed by Mr. Moret during his testimony. I agree with the operator and CPW that the mitigation approach can be protective, as described by Mr. Moret. And I also believe that the Grindberg pad is the more protective and is CPW's preferred approach if it is technically doable. So from a wildlife protection standpoint, I believe it's highly preferable to have an extra 2 truck trips a month that are at the Grindberg pad directly off the already trafficked county road, as opposed to the new development of the sumac pad in a more remote, minimally disturbed habitat that's already isolated by topography from the county road and the Grindberg pad. And so while the operator has stated that they will not develop the easternmost bore if restricted to the Grindberg pad, and that would damage correlative rights, I believe that's a choice by the operator, as it is clearly technically feasible and commonly done to step wells out to that degree. So in my opinion, the proposal as currently structured does not adequately follow the mitigation hierarchy for reasons that appear to me to be associated with cost and convenience. And that's precisely why Senate Bill 181 removed the technically or economically feasible exemption language from the statute. I can be supportive of the development if it takes place from the Grindberg pad it's much more difficult for me to be supportive from a wildlife perspective from the SUMAC proposal approach. And that's all I have for deliberative comments, Mr. Chair. Thanks.
Thank you, Mr. Ackerman, for the deliberative comments. Commissioner Messner.
Thank you, Mr. Chair. My comments are going to be similar to Commissioner Ackerman's. I do actually think that it is possible. It appears that it is possible, although I don't know this for sure, that the unit may be able to be drained with the proposed number of wells. I also think it's equally possible that it would need additional wells in order to be able to fully drain the unit. I would defer to staff and their opinion and their expertise as to whether or not there needs to be additional wells in order to be able to address this, whether the proposal sufficiently address this. And I think they're clear in their comments that they believe that it may not be appropriate to fully drain it. The last thing that I want to see from a commissioner's standpoint is operators proposing something and then having to come back after the fact and propose more in order to be able to fully drain the minerals associated with the unit. That's double the impacts associated with a proposal. You know, in land use processes, it's common that you don't allow multiple minor impact land use changes to occur, but rather if there's known impacts that are going to occur, you review that application as a major impact or something like that. I do believe that in this particular situation, if there's known challenges associated with this, then that's not challenges, but known possibilities of needing to be able to utilize additional wells to fully meet the obligations to access the minerals within the unit, then that should be contemplated in the application. And so that the impacts associated with the application, surface impacts and others, can be fully evaluated rather than it being done in smaller increments, ultimately creating a potential larger cumulative impact associated with the development. And so I think it's important to understand that, and I think you know, that economics don't guide the regulatory process. Our regulatory process is guided by avoiding, minimizing, and mitigating adverse impacts to sensitive receptors. And that mitigation hierarchy is central to our regulatory process. It's central to how we review OGDP applications. I think that that's evident in a number of different rules, but in CRS 34-60-103 5.5, minimize adverse impact is defined to mean the extent necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources, to A, avoid adverse impacts from oil and gas operations, and B, minimize and mitigate to the extent and severity of those impacts that cannot be avoided. The 100 series definitions of minimize adverse impacts and mitigate adverse impacts refer to measures taken with respect to unavoidable adverse impacts. Unavoidable adverse impacts are direct, indirect, or cumulative adverse impacts to public health, safety, welfare, the environment, and wildlife resources that are not entirely eliminated through the application of an alternative location selection or other methods designed to minimize adverse impacts from oil and gas operations. The SBP states that the commission defined the term unavoidable adverse impacts to articulate how it would address those residual impacts that remain, even after the commission has considered the opportunity and ability to avoid impacts and has included site-specific measures to minimize impacts. This is in the statement of basis and purpose on page 172. So I read that as indicating that the commission must first consider the opportunity to avoid adverse impacts before approving an application that relies upon minimization or mitigation processes within the application itself. And so I think in this particular situation, we've got an application that is proposing new surface disturbance where there is existing surface disturbance that technically could be utilized. I do believe that this commission is obligated to avoid first, and that it is necessary to avoid in the mitigation hierarchy. And avoidance in this particular station means to utilize existing pads and the surface disturbance associated with those, particularly in a situation where those existing pads are closer to the road and will reduce the impacts of truck traffic. This potentially would be a different situation if there was not truck traffic associated with this development by having oil takeaway versus having to truck the oil away. But that truck traffic alone is significant and has the potential to have adverse impacts to wildlife in 3 different high priority habitat areas. I think that is also a compelling reason for me to take issue with this particular application. And so for those reasons and other reasons, I think clearly articulated by Commissioner Ackerman, at this point, I don't believe this meets the standards necessary for approval.
Other commissioners with deliberative thoughts? Commissioner Cross.
Thank you, Mr. Chair. And thank you to my fellow commissioners for their comments. I'm going to say this application raised a lot of questions for me, and I do appreciate today's presentation, especially with respect to the issues related to correlative rights, to waste, to stranding potential minerals. I think that was helpful. And I also think it would be helpful to make for operators in the future to make sure that we have some of these issues ready to address when first brought before the commission. Because I do think that the operator did provide a lot of answers that would have been helpful to know when we first heard this a couple of weeks ago. I'll start off with the issues of correlative rights before I move on to the wildlife concerns. And I think with respect to correlative rights, I think that as proposed, especially with, we'll call them more experienced mineral rights owners, that we do have less of an issue with correlative rights here. I think that there potentially will be minerals that are not going to be developed. Similar to Commissioner Ackerman, I do agree that additional wells should not be proposed merely because additional wells could be proposed, but to make sure that operators are really thinking through their development plans to make sure that if they really are only going to develop 4 wells, let's not propose 16, let's not propose 32 and only drill 4. I don't think that it is helpful when we start looking at projected cumulative impacts if you take that approach. And so I do appreciate that 4 is what the operator really wants to propose. I think consistent with Commissioner Messner's questioning today, I do think I agree that it is concerning, though, the idea that potentially like, oh, this turned out to be very economic, let's go back and let's try and do more, because then we're not doing an adequate job of looking at what potential impacts to an area might be. That said, I appreciate that the recognition that all minerals may not be developed, but also the recognition that everyone's aware of what the development plan is, what the proposals are. And so at this point in time, I have no issues with the OGDP with respect to the correlative rights issue. And one of the reasons that I think it was particularly helpful to have Mr. Moret come before us today was there was a lot of, at least in my mind, some consternation about, is this going to be protecting wildlife? Because we did get a clear indication from CPW that it would be preferable to not have anything in habitat, high priority habitat, and fully understand and fully appreciate that we're not supposed to have anything in habitat, avoid the high priority habitat to whatever extent possible. And then the question ultimately becomes, if you can't avoid habitat, can you adequately take steps to minimize and mitigate any adverse impacts to that high priority habitat under the proposed OGDP? And ultimately, our goal here is not to say there could be a better location, or I wish you would have chosen this location. Our job as commissioners is to say, is the location proposed within our rules to be approvable? Is the information provided approvable? Not say, we want to do it here instead. And so I do have some concerns with the operator's suggestion that, you know, a 3,400 foot step out is not feasible, is not appropriate, and that they may not develop at a 3,400 foot step out. As Ms. Byrne indicated earlier today, I think that you see operators all over the state consistently doing step outs of that nature. So it does concern me a little bit, and I do think that likely the Greinberg location probably would be a better location. But again, it's not my job as a commissioner to try and say, I want you to do this. It's instead, let's look at the proposal given, and under the proposal given, does it meet our rules? And so consistent with what Mr. Moret said today, the fact that moving it outside of the habitat area and completely avoiding the habitat area was not feasible. Are they taking the sufficient steps to minimize and mitigate impacts to still protect wildlife? And I think what we heard from Mr. Moret today is we are. The use of the timing stipulations in particular, I think the reduction of the surface impacts, and that's why I wanted to try and get an idea of, is truck traffic more important? Is the surface disturbance more important? And the fact that he said, I'm less worried about the truck trips, I'm more worried about the actual surface disturbance. And I think what I heard from Mr. Moret today and what we're hearing from CPW is, yeah, they couldn't get outside of high priority habitat. So the additional steps that the operator is taking, proposing with their BMPs, the COAs that staff has proposed, that will protect wildlife resources. And so while I may have concerns about what the best alternative location may have been and what should have been done, I do think that what has been proposed to us, especially after today's presentation from the operator concerning some of the questions I had with respect to engineering and drainage, I do think that this complies with our rules and regulations, and I do think it's approvable.
Thank you, Commissioner Cross. Further deliberations, Commissioner McGowan.
Thank you, Mr. Chair. And I will say I appreciate when Commissioner Ackerman goes first, because he almost always says what I want to say, but he says it better. I feel like the point of us doing alternative location analysis with an operator is to show that the proposed location is the only appropriate location that is left. It is the best location. Other locations are not available. And I'm not convinced that the operator showed us that the Greinberg location is not a feasible location to use. I think it's an inconvenient location for them to use. they've talked about how the long step out is going to create more truck traffic, but they haven't said that they actually can't do the step out. That is just more difficult and I think more inconvenient for them. And what I hear Mr. Moret saying in his testimony is the preferred location is an existing location in this high priority habitat with 3 habitats in question here. The county road is already in existence. The existing pad is close to that county road. And so I'm not convinced by what the operator has put forth that the alternative location analysis has shown that the proposed sumac location is the most appropriate location for this development. And I'm not sure I'm convinced by the, more waste or correlative rights not being honored, because we already are admitting that by just drilling the 4 wells, it is more than likely that we are leaving minerals undeveloped already, and that the folks who own the mineral rights are aware of that. And I think if you pick the Greenberg site, those same mineral owners are going to have to decide if that type of development with not complete development on the east side is acceptable to them, or whether you change the DSU size and make it smaller. And so that's kind of what I'm thinking right now.
Mr. Chair, if I may, I do have one follow-up comment that I have to address. I do want to briefly address the question posed by Ms. Trask during her testimony today. And I will agree with Commissioner McGowan that I do think it is somewhat of a case-by-case basis. And admittedly, having not gone through all the legislative history and some of the discussions on that legislators underwent on the House and Senate floor, to me, in looking at the up to means that we're not specifically looking only at full development, but it's more of a, we don't want to go above and beyond. And so while the legislation talks about potential overdevelopment and it talks about waste of resources, what we often see is that, and geology and engineering testimony will show, is you don't get 100% of the resources. And so I think, consistent with what we've brought up several times today, we don't want to over permit just to say that it's the potential maximum development. I read the up to in section 3460-102 as meaning up to its maximum efficient rate of production, as meaning that we're not going to go above and beyond. And so in that sense, we're not going to take steps to say it has to be appropriate with the DSU size, so you're not stranding the minerals, as might happen if you only did 1 well in an area and saying, we're definitely not going to be able to get this. But I think the up to is more of a ceiling there of saying, don't permit more than would be necessary to develop it. I just wanted to make sure I made that point.
Great, thank you. I guess my comments are as follows. I think this is, I think it's a difficult decision for the commissioners. Getting to the well number piece, I'm comfortable with the wells as proposed, and I do not like the precedent of an applicant over committing on wells when they're not planning on doing that. I'm also influenced by the fact that we followed our rules and regulations. All the mineral interest owners received timely and accurate legal notice. None objected. The largest mineral owner is a sophisticated mineral owner, being Anadarko, so they know what is going on. So I'm comfortable with that. I appreciate staff bringing the point to us. And I possibly would like to have further discussions with staff outside of a specific application to further understand the nuances here. This is kind of a new thing for commissioners and for staff, but I'm okay with that. What I find with interest is this wildlife piece. And Commissioner Messner, I did the same thing. I went back and pulled the statute and the SBP and read it. And I think from this commissioner's perspective, we're missing out a little bit the reasonable and necessary perspective that's within the statute. that you would avoid as is reasonable and necessary. And in this instance, I'm also, and here's the hardest part. I've got Commissioner Ackerman with esteemed knowledge in CPW and wildlife, and I've got our wildlife biologist, and they're not actually singing the same tune, at least if I'm listening correctly. And that puts me, not the wildlife guy, in a difficult position. And I'm not faulting that. That's part of the process, right, guys? But as I see it, this is a situation where, based upon the information from the operator, avoidance cannot completely occur. And in that case, then you minimize and mitigate in a reasonable and necessary manner. And the whole framework establishes that there will be times when you cannot avoid. Thus, you have the minimize and mitigate in a reasonable and necessary manner. And as I'm listening to the CPW biologist, he was not hard in saying no. In fact, I think he said that the minimize and mitigate was sufficient, in particular with regard to the timing stipulations and some of the other things that Commissioner Cross raised. So I am a reluctant, but think appropriate that this could be approvable based upon the information that we have before us. With regard to the issue of step or Red Rover development, or I think Commissioner Messner, you pointed out that you have concerns that they need to come back and get more wells. I think this commission is required to evaluate what is before us today. And in that evaluation, I find this to be approvable. Now, if they come back and decide later that another 4 wells are needed, we will then evaluate that application at that date. And it may or may not be approvable based upon the cumulative impacts between this application and that application. But at least from my perspective, I'm not feeling a need that we would need to evaluate something that is speculative at this point. And again, I get back to the first point, is I appreciate that the well numbers are what they are. So those are my comments. I guess the other thing, and this is just kind of for everybody's purposes, I didn't like how this played out a little bit, where we're having a hearing and coming back and having another hearing and having our wildlife subject matter expert having to sort of testify on the fly. And I don't know if there's a way that we can not make sure that doesn't happen in the future. But for all of these issues, I think those things need to be further fleshed out. And I almost would suggest to commissioners that if we get to a spot like this and Mr. Moret is having to get a reassessment of what the current plans are, that we ought to continue it and give Mr. Moret and the applicant and our staff the full opportunity to fully vet this, because I think the 5 of us are, I think all 5 of us are probably a little bit uncomfortable with where this is shaking out. And I think there are things that we can do to avoid that. So those are my deliberative comments. Does anybody else have further deliberative comments? Commissioner Messner.
Thank you, Mr. Chair. I always appreciate your perspective, even if we don't always agree. But I think the avoid thing is it's interesting because I mean, to me, when I read it, it didn't say just avoid high priority habitats. It's avoid adverse impacts to the wildlife. And so certainly avoidance of high priority habitat is one element of that, but the avoidance of impacts, adverse impacts to the wildlife, to me, is really the guiding line on this one. And so as I listened to Mr. Moret and I listened to Commissioner Ackerman, it appeared to me that the timing stipulations, are not the most protective way of avoiding adverse impacts to wildlife, but rather the utilization of existing pads, minimizing, activity that potentially impacts these different species associated with the high priority habitats, minimizing the truck traffic that's associated with it out of away from already existing and utilized roads. To me, that ultimately becomes the avoidance piece, is how do you avoid that impact rather than having to mitigate it or minimize it. So to me, mitigating and minimizing, minimizing being, okay, if we can't avoid it, if we can't utilize existing surface disturbance, if we can't utilize a location that minimizes new disturbance or new access roads, then we can minimize it by utilizing timing stipulations, understanding that there's still going to be truck traffic and there's still going to be activity, but you're going to minimize that. You're going to minimize it by utilizing the timing stipulations. And then in lieu of all of these things, or in combination, you would then mitigate utilizing the offsetting mitigation fund structure. And so that's how I interpreted the avoid, minimize, and mitigate. Certainly, a great avoidance would be to minimize that high priority habitat altogether, but there's still avoidance within the high priority habitat that needs to occur from this commissioner's perspective. And so that's how I looked at it, just FYI.
No, and I appreciate that. And I'll follow up with this. The minimize adverse impacts definition is prefaced based upon the extent necessary and reasonable. And it deals with 5 subject matters: to protect public health, safety, welfare, the environment, and wildlife resources. And from this commissioner's perspective, 4 of those 5 are met to the extent reasonable and necessary. And it's a game day call on the wildlife resources, given what we heard from Mr. Moret. So if I'm looking at all of that collectively, which I think we're supposed to do, 4 of the 5 protections are met to the extent reasonable and necessary. And the 5th, wildlife, it's a game day call. So just to further sort of refine out how I'm trying to apply this, and I think this is probably the first instance in which we as commissioners have had to focus in on those words necessary and reasonable. I think, the other application in which it was denied, it was not a game day call. I think it was pretty fundamental and we were all pretty comfortable with the decision. This one, and we're going to face these guys. This is part of the job, but I just wanted to sort of further amplify it. Your further amplification helps me, Commissioner Messer. So I wanted to further amplify as I look at the definition and what it is we're supposed to make sure that we're doing. And in this instance, I believe that the majority of the adverse impacts are being addressed reasonably and necessary. Commissioner Ackerman.
Thank you, Mr. Chair, and I appreciate the additional discussion. It's very helpful for me, and appreciate it from you and from Commissioner Messner. And I especially appreciate you focusing on the reasonable and necessary language. I thought about that as well, and I think that's why, to me, from a wildlife perspective, this hinges entirely upon, how out of the ordinary is it to step out a well far enough that it can be reached from the Greenberg pad. And if it were a significant step out that was outside the norm of step outs that are being done, I do think there's an argument that, it's reasonable that the operator would have a concern with step outs that are, even though it might be technically feasible, step outs that are farther than commonly done. And so the decision to me kind of hinges upon, this is a pretty common step out distance, an exemption from that because this operator will choose not to do it. To me, doesn't maybe meet the standard of reasonable and necessary. So that's, kind of my further elaboration.
All right. Further discussion from commissioners? Commissioner Cross.
Thank you, Mr. Chair. And I'll just kind of conclude by saying I appreciate the the back and forth, because I think there are valid points made with respect to the avoid, minimization, and mitigation. I think, as you said, I think ultimately when you look at avoiding the adverse impacts, I don't think there is avoiding adverse impacts under any development proposal moving forward. And so I think that's where we do look at the minimization and the mitigation. And so I think that's why I kind of land in that area of based on what Mr. Moret said today, the understanding that those steps, while maybe not the ideal situation, still do take the necessary steps to minimize and mitigate the adverse impacts.
All right. Seeing no further discussion and seeing that we may be going in different directions, Ms. Larson, can we have a roll call, please? Or actually, do we have a motion?
I'll vote for approval of the application with the modified BMP that they would be plugging and abandoning the Grindberg pad as opposed to the injection well option.
Okay, I'll second the motion. Further discussion? Roll call?
Yes, Commissioner Ackerman,
No.
Commissioner Cross,
Yes.
Commissioner McGowan,
No.
Commissioner Mesner,
No.
Commissioner Robbins.
Yes. Motion fails 3-2. Do we have a second motion? Commissioner Ackerman?
Mr. Chair, point of clarification, excuse me, Commissioner Messner, I apologize. Point of clarification, I mentioned during my testimony that I would be amenable to this development going forward if it were shifted to the Greenberg pad, but my understanding would be that the existing application would need to be amended and we'd need further work to do that. So that type of a motion wouldn't be appropriate at this time. Is that correct?
AG Mercer?
Thank you, Mr. Chair, and thank you, Commissioner Ackerman, for the question. I think that, it is an option always at the commission's disposal to stay an application if you feel that you don't have, excuse me, the necessary information right now to comfortably come to a final vote on it. So I do think here one option would be perhaps to give the applicant the option of a stay during which they could amend their application to utilize the other location. It would need to be, I'd imagine, a fairly lengthy stay because it would require new notice to the party or notice to mineral owners and property owners. It would also require a full staff analysis of a revised proposed development. So that could be an option here. Another and perhaps cleaner option would be if it's the commission's pleasure to vote simply to deny this application that's before you and just let the applicant know that if they'd like to bring forward an application from the Grindberg location, that the commission would certainly consider that application.
Okay, with that, and not to put the applicant on the spot, but I think I'm putting the applicant on the spot. Ms. Wazelinski, did you want to provide any narrative to the options as articulated by Ms. Mercer?
Yes, thank you, Chair. Right now, the application is for sumac. And so, right now, the use of the Grindberg pad is not before you. So I would need to confer with my client, but, I would say staying to amend to use the Grindberg is not what's before you today. And we would need to file a new application and go through the new OGDP process with that. If there is an opportunity to continue discussions with Mr. Moret, I know CCRP would be very open to that, particularly with regard to changing kind of the overall development by getting rid of that Grindberg disturbance, if that would be appropriate for a continuance. However, what's in front of us right now is sumac and not Grindberg. And so I think, I don't think we'd be willing to have a stay to refile at this point, but I may need a few minutes with my client before I affirm that.
All right, well, let's do this. There's no reason to be hasty. Why don't we break for lunch and come back at, say, 1:30? Or actually, can we come back at like 1:15? I've got a 2 o'clock that is a hard stop that I need to attend to. Would that be okay, Ms. Wozlinski?
Yes.
Okay, let's come back at 1:15, and we'll take a lunch break between now and then. All right, welcome back, everybody. We are back on the record at the Colorado Oil and Gas Conservation Commission. We took a bit of a break. Ms. Wozlinski, I believe it's appropriate to hear from you and your client at this time.
Great, thank you, Chair. So, what's before us now is consideration of a stay, and CCRP is not going to agree to that at this time. The option to refile for Grindberg is just simply not one that will be pursued by CCRP. And those are for the reasons we articulated today, being that development from Grindberg will not result in efficient or economic development. It could create waste, it would create waste and harm correlative rights. So we would respectfully not agree to a stay to refile for Grindberg. But I do want to address something that Chair Robbins raised in your deliberations today. And that is that these are novel issues being raised. And Mr. Moret was put in a hard position today by opining on CCRP's modified development plan on the spot, meaning he's not really been afforded the full opportunity to weigh in on the Sumac development, considering the commitment to plug and abandon and reclaim the Grindberg well and not evaluate that well for saltwater disposal. So if it would benefit the commission to continue this matter so that Mr. Moret is able to formalize his thoughts, CCRP would support that. We also have a lot of data about why a step out is not feasible in this area far north of the core of the DJ, and believe that a continued discussion prior to a formal vote would be beneficial to the commission and to Mr. Moret. So just wanted to make that point for consideration before your vote on the motion.
Okay, thank you very much for that. Does any commissioner have questions for Ms. Wozlinski with regard to those statements? Yeah, and we don't have to have questions, just making sure we give everybody the opportunity. Okay, with that, we're back into deliberations. Does any commissioner desire to further deliberate or to make a motion? Commissioner Messner.
Thank you, Mr. Chair. I appreciate the thoughts that you had regarding providing a stay should the applicant want to reevaluate their application. And the applicant has indicated that they're not interested in a stay to reevaluate the application based on the feedback provided at this particular hearing. And so in light of that, I think there was an opportunity for the applicant to provide the information necessary to this commission in order to make a determination on the hearing or the application that was provided. And so from this commissioner's standpoint, I think my initial comments still stand. And so I would make a motion for denial of the application as presented.
I'll second that motion.
Motion and a second. Discussion on the motion. Commissioner McGowan.
Thank you, Mr. Chair. Based on I'm so sorry, I know I keep saying your last name wrong, Wozlinski's comments. I am wondering if other commissioners are interested in understanding better what Mr. Moret might think about the condition of approval that's been added. And I know that several of us are basing what I think is going to be a vote or our opinions on the feasibility or not of using the Grindberg pad. So if that's not the case, then I'm prepared to vote. Otherwise, I'm also open to allowing additional information or discussion.
Thank you, Commissioner McGowan. In the vein of discussing, I would certainly be amenable to allowing Mr. Moret and or applicant and or staff to talk further I meant it when I said that I felt like we were sort of having him evaluate things on the spot. Hearing from the applicant, I'm not sure that the applicant has anything. I mean, they're saying that they can't drill the wells from Grinberg. So I think it really, if there's a continuance, it's really just to allow a finalization of the wildlife piece to be discussed so that when we do take a vote, we know upon which for reals we're voting on. I'd be fine with that. That's just one commissioner. Other commissioners with thoughts? Commissioner Messner?
So I mean, I do have thoughts, and I mean, we had a hearing on this application once. We've continued it a couple of weeks to allow the applicant to make adjustments or modification. Now we're considering staying it again. And so this application is a moving target. If we continue to do this, I think the applicant had an opportunity to present the information and to the commission in order to make it, the commission to make a determination whether the application was approvable. I think the applicant has made that, has presented that information to us. I think if the applicant wanted to provide Mr. Moret an opportunity to review their current proposal, they had 2 weeks to provide Mr. Moret that information and get comments from Mr. Moret. Sounds like Mr. Moret was seeing this for the first time today. And so that's not the burden of this commission. That's the burden of the applicant to be able to provide that information. And so I'm not sure what we're going to accomplish further by continuing to allow this application to evolve over multiple hearings. It seems like an inappropriate practice. That's just my thought.
And I appreciate that, Commissioner Messner, but I also am of the opinion that I want us to get to the right decision. And if for better or worse, Mr. Moret wasn't necessarily apprised, I mean, it's not a hang you sort of situation. So, I mean, again, I'd be comfortable in another couple of weeks, but that's just one, folks. Commissioner Ackerman.
Thank you, Mr. Chair. I feel much the way that Commissioner Messner does. I'm definitely a proponent of further analysis and further discussion. But what I heard from Ms. Wazelinski on behalf of the operator was they're not really open to solutions that have been discussed before the commission today. Rather, they would just want to have further discussion about convincing why it's impossible to do so. And I do feel like they had an ample opportunity to provide any engineering testimony or other testimony or other data that would substantiate the impossibility or extreme difficulty of doing something that's commonly done. And so if we feel like further conversation can have some two-way discussion about workable solutions, I think there's some value there. But it is difficult for me to continue this hearing to have the same discussion that we've had the last two hearings.
All right. I think we have a motion and a second to deny the application. Can we have a roll call?
Commissioner Ackerman,
Yes.
Commissioner Cross,
No.
Commissioner McGowan,
Yes.
Commissioner Messner,
Yes.
Commissioner Robbins.
No. Motion to deny the application carries 3-2. This matter is now finalized. Thank you for the presentation, Ms. Wazelinski. Always appreciate your professionalism. With that, commissioners, I do not believe we have anything further on our agenda today. I would look for a motion to adjourn.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We're adjourned. Thank you, guys.